The court will consider that along with the victim impact statements that I received from Ms. Haywood and Ms. Johnson. The court has, in anticipation of today's sentencing, reviewed and considered the purposes and principles of felony sentencing. I've certainly presided over the trial, the entirety of the trial. I heard the evidence firsthand. I'm considering that as well as I sentence you, Mr. Bumpass. Identifying what I've reviewed, certainly the pre-sentence investigative report, victim impact statement, letters that have been received from family members. Looking at the purposes and principles of sentencing, first thing I have to look at is Mr. Bumpass's prior criminal contacts, if any, and he does have criminal contacts as an adult. Back in 2007, he was convicted of theft by unlawful taking in Clermont County, Kentucky. Ultimately, it appears that he was convicted of that offense in 2007. In December of 2007, there was a robbery offense, which was reduced down to a theft by unlawful taking, and he was sent to prison in Kentucky. So that's the first Department of Corrections number he has. So he served a prison term previously on that. And in 2008, November of 2008, another theft by unlawful taking charge where he was incarcerated in Kentucky prison on that as well. So the record reflects two separate prison numbers, two separate prison stints for Mr. Bumpass. So he's committed prior criminal acts and he served prior prison terms. The court has to look at the offenses to determine whether they are the seriousness level of them. Not obviously any felony is serious, but the legality of there's a legal terminology, if you will, in regards to seriousness factors. Statutory language that the legislature gives us, there's certain factors the court has to look at to see if an offense is more or less serious than conduct normally constituting the offense, or offenses that typically occur. As far as serious factors under 29-29-12, after reviewing those, the court is going to find that the offense, certainly both offenses in my opinion, are more serious than conduct normally constituting the offense. One of the factors is certainly relationship that you had with the victim here facilitated the offense. This is someone that you were friends with at the time of the commission of the offenses, that trusted you, and your relationship facilitated the offenses in the court's opinion. Other relevant factors as to whether the conduct is more serious, I would observe that, and I would agree with the state, that these are both the worst form of the offenses. And as far as tampering with evidence goes, I see a lot of tampering with evidence charges. Typically, that's somebody hiding, contraband or drugs or something like that on the floorboard, throwing it out the window. This is on the whole other scale. This is you secreting certainly a body as potential evidence against you. So this would be, on a scale of 1 to 10, this is the 10. This is the absolute worst form of a tampering with evidence charge that I have seen through my experience. As far as the abuse of a corpse, you don't see a lot of these type of cases, but they do exist where someone's taking pictures of dead bodies in the morgue or whatever it may be. This would be on the other end of that spectrum. Here, this is you disposing of Paige Johnson's body in a manner, I think it was described as disposing her like trash by the prosecutor. So that's exactly what we have here. So the abuse of a corpse, I think, this would be the worst form of that offense as well. And certainly your efforts to tamper with that body and that evidence precluded certainly law enforcement from determining any type of cause or manner of death. So I think it's the worst form of the offenses. As I see your prior criminal history, Mr. Bumpass, I see an escalation in criminal conduct. You go from theft-related offenses, where you went to prison on this, to these type of offenses, which in my estimation are much, much more serious. So there's an escalation of criminal conduct. Recidivism factors under 29-29-12D, that is his likelihood to reoffend. I would find that recidivism on whole is more likely. At the time that you committed the offense, you were under release from confinement. Specifically at the time of the instant offense, you were on post-release control and or parole through Kentucky authorities. So under their supervision, you committed these offenses, which makes recidivism more likely. You, as I alluded to, have a prior history of criminal convictions, and you've had other contacts with other courts that did not deter you from committing this offense. In other words, you've not been rehabilitated to a satisfactory degree prior to committing this offense, and you've not responded favorably to sanctions previously imposed for other criminal convictions. Last, but certainly not least, as far as the recidivism factors, the court finds that you show no genuine remorse for your conduct. The count 2 is a felony of the 5th degree. The court will certainly overcome presumption for community control or probation. This involves, again, I believe, the worst form of the offense. And you committed this offense while you were serving or under previously sanctioned from a prison term on parole. And you've committed that offense while under sanction from parole, and you've previously served a prison term, which allows the court to overcome a presumption for prison on a felony of the 5th degree. Certainly the pain, suffering to the victim's family is unmeasurable. For many years, you've avoided the consequences of your actions. We've heard that said today, and I think that is certainly true. The courts considered the purposes of principles of sentencing, including the minimum sanctions necessary to accomplish the purposes of sentencing without imposing an unnecessary burden on state and local government resources. Just so the record's clear, I'm finding that the offenses both are more serious than conduct normally constituting the offense, and recidivism is more likely. I'm finding that prison is consistent with the purposes and principles of sentencing, that community control is not, and you are not amenable to available community control sanctions. Ms. Haywood, when she began her statement this morning, and had a quote from Dr. King. It's actually, he's quoting I can't offhand tell you who it is, but it's an older quote from an old jurist, and it's an old proverb, if you will, or saying in the law that justice delayed is justice denied, and that is certainly the case here. Ms. Johnson's family's waited, I think, 13 years for you to be brought to in front of a jury of your peers. What struck me, I guess, listening to the evidence was the callousness that she showed and the indifference, lack of compassion. And the best, I think, example of that was the testimony of Ms. Johnson, where as the mother of a child who's been missing for less than 48 hours, you're the last person seen with her. She goes to your home to inquire, hey, you're her friend, have you seen my daughter? And you slam the door in her face. Doesn't get much more cold-blooded and callous than that, Mr. Bumpass. No empathy for what happened to Paige, no empathy for the family, no concerns for Paige's body or her remains. This is a friend, somebody that trusted you that evening. We've certainly escaped punishment for, I think, 13 years. But what's clear now is that everyone sees you, knows the truth, and knows what you did. I have to sentence Mr. Bumpass within the bounds of the law. The law here, there's a tampering with evidence charge, which carries a maximum 36 months in prison, and the abuse of court charge carries a maximum prison term of 12 months. So 4 years is the maximum that I am allowable or permitted under the law. These crimes don't, if these crimes don't warrant the maximum term, I'm not sure what does. 4 years maximum possible penalty certainly does not equate to the severity of your actions and the harm that you've caused to Ms. Johnson's family, to the community. But I don't make the law. I enforce the law. And I am going to impose the maximum penalty that I can impose in this circumstance. In doing so, I'm going to find that prison is consistent with the purposes and principles of sentencing, that on count 1, you will be ordered to serve 36 months in the Department of Corrections. On count 2, you'll be ordered to serve 12 months in the Department of Corrections. You will serve those consecutively for an aggregate prison term of 48 months or 4 years. In order to impose a consecutive sentence, I have to make findings, which I'll do so at this time. Court finds that consecutive sentences are necessary to protect the public from future crime from you and to punish you. that consecutive sentences are not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. Consecutive sentences are necessary to protect the public from you. You are highly likely to commit future crime given your history of criminal conduct, the lack of remorse, the danger you pose to the public, and certainly the manner, the callousness of the crime, I think. So certainly consecutive sentences are necessary to protect the public from future crime, which looks primarily at your prior criminal history, and I see an escalation of criminal conduct there. It's not disproportionate to the seriousness of your conduct and the danger you currently pose to the public. The court finds further that you committed one or more of these offenses while under post-release control for the felony offenses in Kentucky. You're on parole in Kentucky when you committed these offenses. In addition, at least two of the multiple offenses committed here as part of one or more courses of conduct and the harm caused by two or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of the course of conduct would adequately reflect the seriousness of your conduct. These are separate individual criminal acts with different harms involved. To run these concurrent or together would demean the seriousness of the tampering with evidence charge and the separate abuse of corpse charge. And finally, you have a history of criminal conduct that demonstrates that consecutive sentences are necessary to protect the public from future crime by you. In imposing the consecutive sentence and the maximum sentence, the court has considered the aggregate term here of 48 months, which is certainly proportional to the crimes here, the harm caused, the necessity to protect the public. The case law the court's guided by, I have to look at the aggregate sentence, consider the number of sentences that I'm imposing consecutively. Consecutive sentences are necessary, again, to protect the public. Is dependent on your criminal history, which certainly demonstrates the need for you to be incapacitated for a lengthy term of incarceration. Each sentence on individual account should be imposed consecutively, and I have considered the aggregate term. I've made the necessity findings that I believe I need to make. I've considered the overall prison term when imposing that. Imposing consecutive sentences, I have considered each sentence on individual counts that I intend to impose consecutively on you and that aggregate term that will result. So I've considered the necessity, I've certainly considered proportionality, and the aggregate term that I'm imposing for 48 months. He gets credit for 48 days that he served. Mr. Zipper, my hope is that you discuss with Ms. Johnson, Ms. Haywood, why the court cannot impose the restitution amounts that were requested.
I have, Your Honor.
Okay, very good. And then for those reasons, that there's lack of verification, the court can't impose it. I will not be imposing the restitution that's being sought by them in the pre-sentence investigative report. Court costs will be imposed. Post-release control when you're released from prison, Mr. Bumpass, is optional up to 2 years. If you violate that post-release control, the parole authority could return you back to prison for up to 9 months for each violation, up to a maximum of half of your original sentence here. If you're convicted of a new felony while you're on post-release control, in addition to any prison term imposed for the new felony, you could receive an additional prison term of the greater of 1 year of the time you still have remaining on post-release control. You are now ordered to serve as part of this sentence any period of post-release control imposed by the parole board and any prison sentence imposed for a violation of that post-release control. Court cost will be imposed. You certainly have the right to appeal. You're well aware of that. The conviction and the sentence of the court, if you're unable to pay for the cost of appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be afforded without cost to you as well. If you're unable to pay for the cost of documents necessary for an appeal, they'll be provided without cost. And you have the right to have notice of appeal filed timely on your behalf. The final thing I would indicate certainly is that, let me ask, Mr. Zipper, on behalf of the state, anything I omitted or failed to advise Mr. Bumpass on?
I don't believe so, Judge.
You know, the courts, if I had a magic wand, certainly, you know, I see the pain throughout the trial of the Johnson's family. You know, certainly we're all human beings involved in the system. I'm sentencing you, Mr. Bumpass, based upon the law and what you did. A alone, without concern, if you will, in regards to that. The court has to approach that in a very methodical way in order, but certainly the court understands I can't understand the pain, but I understand the circumstances here. And my hope is that the family of Ms. Johnson is able to find some peace now. Her remains have been recovered. Now Mr. Bumpass has been sentenced to the maximum, to the fullest extent of the law that I can impose. So my hope is that they find some peace going forward. With that, he is committed to the custody for imposition of his 4-year prison term. Anything in addition, there's court cost, obviously restitution for obvious reasons, as indicated. I can't impose that. He gets credit for, I think, 48 days served. Anything that I missed?
I think you've covered everything, Judge.
Mr. Serkin, you're filing, I think you're filing maybe an appeal. Anything that you need to make on the record before he is committed to the custody of the sheriff?
No, Your Honor.
Okay, very good. All right. We'll stand adjourned.